Marvel and DC just lost a huge deal in court. But what does it actually mean? Well, we're going to take a couple minutes to talk about the recent court case that saw Marvel and DC lose their trademark status to the term of superhero. Let's take a couple minutes to talk about the case, what it really means, and how ultimately it probably won't have much impact on the industries we all love. Well, many people don't know it, but Marvel and DC for the longest time owned a trademark to the term superhero. Now, this meant only Marvel and DC comics could refer to their characters as superhero, and this is why in many other comics they're referred to as enhanced or special or some other term besides superhero. Now, the US Patent and Trademark Office recently, the US Patent and Trademark Office has completely shaken things up because that long-held trademark by Marvel and DC has now been canceled. Now, this comes via an announcement from a law firm named Reitman, Jorgensen, Liam, and Fieldberg, and they recently declared victory over Marvel and DC in a case over the word superhero. Their request was granted after Marvel and DC failed to get some response to a court request over the challenge to the joint trademark, and now that it's been canceled, their clients, which was Super Babies Limited, can use the term without issue. This also means many other companies that want to refer to the term superhero can actually use it. This could be relevant in not only comic books, but many other areas such as role-playing games. So expect to see the term of superhero used a lot in the coming months. Now, DC and Marvel actually got this joint trademark way back in 1977, and it was for the specific term of superhero. Since then, they've had an undefeated record defending the trademark multiple times, and this includes both in the United States and internationally. But this new challenge to the trademark was made back in May. Now, like I said, the challenge was issued by a company called Super Babies Ltd. And by Scott Richhold. And then what they stated was the term superhero, as well as terms like superhero or super-hero, are generic terms, and they're really not entitled to trademark protection. And in their petition, they said that Marvel and DC were wrong, and it doesn't really allow them ownership over an entire genre. Probably the best other example of terms like this could be the term cola. You have Coca-Cola and Pepsi-Cola, but there are many other variations from RC to Shasta to whoever bottles it locally to you. Cola is referring to the type of soda and not a company, and therefore this would be the same as Pepsi and Coca-Cola trying to trademark the term cola, hold on to it, and not allow anybody else to refer to their drink as a cola. Now, this was one of those things many people were waiting to go against Marvel and DC for a really long time. It probably won't impact anything that they do in the future, and it'll just allow for competitors to use the word in their product, nothing more. Expect in the coming weeks a flurry of other companies using the term, but the pendulum will definitely swing back and it'll stabilize inside of the next couple of weeks. I think this is probably good for every creative. Marvel and DC holding this solely really was, well, sort of weird. And honestly, you can look at any of the creators, even the low-level creators on social media, people that are kickstarting their projects, or just people that are working on their own work. Now they'll be able to refer to their creations as superheroes, and maybe that'll give them a little bit of a better chance in the overall market, or at least provide some inspiration for those projects. In any case, this is definitely a win for the little guy. And that's something we all like. I wish Super Babies all the luck, and I am really curious who's going to be the first big third-party comic provider to start using the term. We're going to have to wait and see.